Hello, everyone. Welcome to Court with Krissy. First, you catch feelings, and then you catch charges. I can't wait to fall in love. I hope you like it. Court with Krissy is now in session.
Tell me again who we have at ACDC?
This is number 5, Collier.
Okay. Good afternoon, Ms. Collier. You have been charged in case 24 CR 007609C with battery, family violence, and cruelty to children in the 3rd degree. Is your history, Mr. Howard?
Ninth arrest, 2021 disorderly, 2015 simple battery dismissed.
Okay. Ms. Allen?
I apologize. 1 second. Mrs. Collier.
Yes.
Yeah.
Position number 5.
Go ahead, Mrs. Desiana.
Sorry, that's my case.
Oh, okay.
Your Honor, this incident took place on November 11th at the residence of the victim, Javon Hunter. These parties have a child together. Officers responded to a domestic dispute. Upon arrival, they made contact initially with the defendant, who stated that she was pulled out of her car and struck on the head and choked, and then she blacked out and couldn't remember anything else that had happened. When officers asked if she could identify the person who attacked her, she could not provide a description. The victim, Javon Hunter, then, while police were on scene, came walking up. This is an apartment complex. He was walking up from the front of the complex with the party's infant child in a stroller, initials TH. He told police that the defendant came to his residence to drop off their child, and there was an argument that had happened from the day before that had bled over into the incident date. He says that the defendant tried to run him over, and when she did that, he then pulled her out of the car and took the car and drove it to the front of the apartment complex to get their child away from the situation, and then walked back up to the location without her vehicle with the child in the stroller. When the victim came back to the location with the stroller, while in the presence of officers, the defendant ran and attacked the defendant, striking him multiple times. The victim sustained a cut on his left cheek. And based on the conflicting stories of what had happened prior to police arrival, the police didn't charge any charges associated with the events that took place prior to police arrival. However, the defendant is charged for attacking the victim in the presence of officers. We've been in touch with Mr. Hunter today. I believe he's also on the Zoom. He states these parties do not live together. They do share a child. They're no longer in a relationship. He states that the defendant also hit him with an umbrella, tried to run him over. He took her car. He states that this is the first time this has ever happened. They've never had any violent altercations prior. He states that he is not in fear and is okay with continuing contact. Your Honor, the state's recommending, based on her criminal history, a $2,000 surety bond on the battery, a $500 surety bond on the cruelty, no further violent contact, anger management courses, no weapons, drugs, or alcohol. We would certainly recommend at this point that these parties, if they're going to do custody exchanges, do so through a third party, since this incident did happen at a custody exchange. We'll leave that in the court's discretion. If Your Honor can sound for Mr. Hunter.
Mr. Hunter, I see you on the line. If you would like to address the court, now is your opportunity. I would need for you to activate your camera, and I'll have to swear you in.
It won't let me. He say the host has disabled it. Okay, I'm on now. Hey, how you doing?
I'm doing well, Mr. Hunter. Let's see. Can you raise your right hand for me, sir?
Yes, sir.
Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can place your hand down. What would you like to tell the court?
I just want to let y'all know she an amazing mother. You see what I'm saying? Like, she didn't deserve that. We just had an altercation the day before. Somehow my nosy neighbors got involved and ended up calling the police. Like we don't even have that goes on. You see what I'm saying? But just this specific day, the police got involved, and it's like my fiance for real. And we just had a little small altercation. And when she pulled up, she got her guard up so much that when she pulled up, she just overdid it a little bit. And that's all. She don't need to be in there.
How old is your child?
She just turned 1.
Okay. And you all share custody of her?
Yes, sir.
All right. You're not in fear of her?
No, sir. No,
And
no,
you
no.
all,
It's I was planning on marrying the next week on our anniversary. Like it's just a lot going on.
and the child, do you share custody of the child?
Yes, sir. We do.
All right. Thank you for being here this afternoon, Mr. Hunter.
Yes, sir. Appreciate
Mr. Cook,
you.
you're on mute, Mr. Cook.
My client is 27 years old, and her position is a lot happened before the police arrived. Apparently, a bystander called the police. She was pulled out of the car and was knocked out for some period of time. Can't identify that person, but suspects it was the alleged victim here. At any rate, the police were there by the time he came back around with the child in the stroller and without the car. So
I'm sorry, Mr. Cook, I'm not understanding what you're telling me. Can you, I don't understand what the scenario that you're, start
Okay.
over again for me. I don't.
Yeah, sure. She came to drop the child off. Her position is that somebody pulled her out of the car and knocked her unconscious.
Somebody like, she doesn't know the person that pulled her out of the car?
She didn't see him. She suspects it was the alleged victim in this case. She didn't see him, or she didn't see the person. And the police were called by a bystander apparently. And then when the police got there, the alleged victim came back around in view with the child in a stroller. Apparently the stroller had been in the car. Where the car was, I do not know at that moment. And apparently that's where the police pick up what they witnessed. So her position is this altercation was started well before the police arrived. Again, as Ms. Desiano said, she can't ID the person. She did not see the person, but
if she believes that it was Mr. Hunter in that regard, then what you're saying is that I should follow the advice of Ms. Desiano and there should be no further contact at this point.
No, my client does not want further contact, Your Honor. None. Okay. And the child has not been legitimated, so she does not believe he should be given visitation rights with the child either.
Okay. Anything further, Mr. Cook?
We would be seeking a signature bond at whatever level the court deems appropriate.
Okay. If nothing further for the battery, it'll be a $2,000 signature bond through pretrial level 1. For the cruelty, $1,000 signature bond through pretrial level 1 makes for a total of a $3,000 signature bond through pretrial level 1. No further contact with Mr. Hunter. She's to stay away from his residence until the child is legitimated. There's to be no further contact. Or I guess at her discretion, if she is the primary caretaker, and no drugs, alcohol, or weapons while out on bond. Okay?
Thank you, Your Honor.
Good luck to you, Ms. Collier.
Next matter is 24 CRB 876, State of Ohio versus Darren Wooden. Mr. Wooden's present with counsel. Mr. Tabler, Mr. King is here on behalf of the Law Director's Office. We're scheduled for a change of plea to a charge of violating a protection order. Mr. Wooden, is it your wish to change your plea to guilty here today?
Yes,
Okay. You understand that a guilty plea is a complete admission of your guilt?
yes,
Okay. Did you sign this change of plea form?
yes, I did.
And did you understand it?
Yes, I did.
Okay. You understand by pleading guilty today, you're waiving your right to a trial, either to a jury or to the court.
Yes,
Okay. You understand you're giving up your right to have a trial?
yes,
Okay. At a trial, you'd be able to call witnesses to testify on your behalf, subpoena witnesses to force them to appear here and testify, and present evidence in your own behalf. You understand you're giving up those rights today?
yes,
You understand you're giving up the right to question any witnesses that the state would have against you?
yes,
Okay. And you understand you're giving up the right that the state prove beyond a reasonable doubt you did in fact commit this offense.
yes,
Okay. You understand if you were to be charged with this offense again, it would be a felony offense.
see. I'm gonna change, I mean, I change my plea, we ain't gotta go to court today, really, on this, if I change my plea. I'm not playing this game like that. Nothing else, because I'm not going to.
We have a brief on
Okay.
it. Okay.
Yeah, I'm not changing that. Next one, if I mean, like, she was the
Yeah, I've
court.
explained.
No, hell no.
I explained this to you, the next violation protection.
No, you never said that one.
Yeah, that's what we meant. The next violation protection order trial will be charged with a felony. If you don't want to change your plea today, we'll stop immediately. We'll set it for trial.
Yes, because I'm not gonna play that where she's allowed to pull and do whatever if shit don't go her way. Or is she gonna allow me to do this today? That's the only way I'm gonna
I
come
have
out.
no idea.
It's the only way I'm gonna do
So you won't have trial.
it. Man, let's go ahead. Yeah, let's go. Let's
No,
proceed
it
with
needs
it.
to
Let's
be, this
proceed
needs to
with it.
be your choice. Do you want to have a trial?
No, I'm gonna proceed with this. I want it done.
Okay. You'd like to proceed, Your Honor?
Okay. All right, Mr. Wooden. You understand if you were to be charged with this offense again, it would be a felony offense. You understand that?
Yes, sir.
Okay. Mr. Tabley, you want to have Mr. King recount the facts today?
No, Your Honor.
Based on that, I'll accept Mr. Wooden's guilty plea as being voluntarily and intelligently made, knowing what his rights are. I'll find him guilty of violating a protection order. The state have a recommendation.
Yes, Your Honor. First and foremost, the protected party has opted out. Based upon what I see in the facts, it looks to me like there were no threats or anything else. It seems like he was the defendant was trying to collect property, but he was by himself, and that's not exactly how it's done.
Okay.
I didn't even see in the civil protection order where there was a standby, but there could have been, and they could have changed that. Therefore, I'm recommending a fine and court costs only.
Okay. Mr. Taylor.
Thank you very much, Your Honor. Mr. Wooden is here today to take accountability. He did assert to me that he was employed at Wendy's up until about 2 weeks ago. He asserts that he had some issues where the protected person showed up at his work. He was of the understanding, now he understands that he's not allowed to contact her back when she contacts her. He asserts that he is now in Recovery Works inpatient facility. He's taking care of some issues. He's been there for the past week. I believe a representative of their facility actually brought him to court today. We too would concur with the fines and court costs. Thank you.
Mr. Wooden, would you like to say anything today?
Yeah, yes, sir. I mean, I'm just gonna speak what's on my mind. Okay. I don't think this is fair at all, right? Because I have a record though, and now I was informed that she's allowed to contact me. Well, I mean, she's allowed to contact me, right? So why am I not? If you're that scared and you got a protection order, why are you? I'm not understanding this whole protection order thing.
Okay. If there's a protection order, regardless of whether she contacts you or not, you can't respond, you can't answer the call, you can't talk to her. Whatever the order says you can't do, you can't do. It has nothing to do with what she does. Okay? You understand that?
Am I able to get one? Am I able to get one? Because now I feel like my life, I feel like I lost everything dealing with this right now. Am I able to get the same, a protection order? Because I feel like my life is in jeopardy now. At any moment now, she can call. If things don't go right with her, things can go right. Just like how I tried to get my property and stuff. Yeah, I could have went about it the wrong way.
Well, you can't answer her phone calls, you can't respond to her, okay?
Yeah, am I able to get a protection order too? Because I want one to go both ways.
If you have grounds for it, you can file for
I feel
one.
like my life is in jeopardy.
Okay, well, you can talk to an attorney about that, or you can talk to a victim advocate about that, okay? Anything else you wanted to say today?
No, it's okay. No, sir.
I'll put a $150 fine in court costs.
All right.
Thank you.
Darren, come to me. Darren, come to me.
All right, Logan Parker.
Yes, ma'am.
Mr. Parker, you've been charged in Butler County District Court, case number 2024 CR 512 with aggravated domestic battery. Well, it's what's referred to as strangulation or choking. It's alleged that on or about the 10th day of November 2024 in Butler County, Kansas, you did knowingly and in a rude, insulting, or angry manner impede the normal breathing or circulation of the blood by applying pressure on the throat, neck, or chest of a person, to wit, Ava Scarlett Parker, with whom the offender is involved or has been involved in a dating relationship or is a family or household member. This is what's known as aggravated domestic battery. As charged, it's a level 7 person felony. The state statute's 2154-14B1 with C2 as the penalty provisions. It is on the non-drug grid under the Kansas sentencing guidelines since it is a felony. Those felonies range from 1 to 10, 1 being the highest, 10 being the lowest. This is a 7. So the sentencing range is 11 months up to 34 months with the Department of Corrections, depending on your criminal history, and up to a $300,000 fine or restitution. If you do not have any prior person felonies, you may be presumptive probation so long as you aren't on probation or parole at the time of this offense. For today, I'm going to enter a not guilty plea for you. I'm going to set your case for a court date and make sure you have an attorney and a bond set. So it looks like your judge that is assigned is Judge Hart. He
Ma'am,
will.
May
Yes.
I say something? May I say something?
Don't say much about your case because you're being recorded and the prosecutor can use that against you.
Well, Ava is a male and laid hands on me first.
Okay.
I was slapped open-handed and punched and jabbed in the throat. All I did was do this right here on the chest to push her away from me because I don't want to be beat by another man. And I don't think anybody in the world would ever want to, especially I'm getting taken away from my daughter, my 4-year-old daughter.
Okay.
And I'm just, I don't know why that I am getting charged for it when she was the one that assaulted me. Yes, her mom over the phone called the cops, but they didn't even take my side of the story or my brother that was standing right there trying to help me.
Okay. So what I'll do is make sure if you can't.
And they let.
Hang
Sorry.
on. If you can't afford an attorney, I will appoint one to represent you. You need to speak with that attorney who will get the police reports. They can file a motion for self-defense, and Judge Hart can listen to evidence at the preliminary hearing to determine whether or not you acted in self-defense. And if he believes you did, he can dismiss the charge. Okay?
Yes, ma'am.
Okay, so, but you're just gonna have to be a little patient here. So he's your judge. The court date for you is January the 6th at 2:30. Are you presently working?
No, ma'am.
I'm going to appoint James or Jim Watts to represent you. He's an attorney in town. He is very busy, but he tries to go to the jail every Wednesday or every other Wednesday. He is leaving town for a bit, which may affect him being at the jail on those particular days in December. But he will be appointed, and the county attorney will provide him with the case materials, and then he'll visit with you about the case and go from there. Now, with regard to bond, at the time of this incident, when you were arrested, where were you living?
I live out at but I was staying with my brother on Broadway in Augusta. I don't know his full address. I was just staying the night there because my wife was sleeping with someone that called rape on her, and I was upset about it. So I went to my brother's to relax and to try to get in a better stability. And then when she showed up and I asked to get my grandfather's speaker, that's when she escalated to pushing me and to
Okay.
throwing
So
keys at me.
is this Ava, your wife?
Yes, ma'am.
Okay.
And I know I call her a she, but she is a he.
Okay.
I've not gone through the surgery all the way yet.
The charge is not gender specific, so that's fine. So what I'm trying to figure out here is you cannot live with Ava or be in the same household or have any contact with Ava while this case is pending. So where will you live?
If I can be bonded out today, I will be going to my grandparents to stay there
And
with my daughter.
And where do they live? Okay.
Douglas, Kansas.
Do they have custody of your daughter?
I have full custody.
Is Ava involved with this child in any way?
She has helped me raise her on and off because she never stayed there. She cheated on me 3 times in the past, so we broke up several times. But my daughter is mine and Hauser's kid, which Hauser is in Wichita, and I have full custody over Olivia.
Okay. How old are you?
I'm 23.
Why can you not seem to get to work?
I tried going when Ava came back to Kansas. I went and stayed with her in Wellington, and my boss would not come pick me up like he said he would for the 2 days beforehand.
All right. Well, I'm going to set a bond here. How long have your grandparents lived in Butler County?
Way more than 23 years.
All right. Recommendation on bond, Mr. Regier, in light of the fact that the next court date will be January the 6th at 2:30, 2025.
Your Honor, notwithstanding the next date of the hearing, the state is recommending, besides the strict no contact order previously referred to by the court, 5,000 cash or surety. As previously observed by the court, count 1 of the information is charged as an aggravated person felony. It is also the state's understanding that at the time of the incident, pursuant to page 2 of the affidavit, The defendant admitted to placing his hands on the throat area of the victim, as well as demonstrated the same act to law enforcement. It would also appear based off page 2 of the affidavit, law enforcement observed a noticeable red mark on the throat area of the victim, as well as the victim being choked to where the victim was unable to breathe based off of the affidavit. And it would appear that this is a case where a witness did observe the alleged altercation on a video call, specifically including the defendant jumping on the victim while the video call was active. So based off the totality of the circumstances, the state does respectfully submit that 5,000 cash or surety with the strict no contact order is appropriate.
Okay.
I don't want contact.
Set your bond at 2,500 cash or surety, no contact whatsoever with Ava, not by phone, not by social media, not through third parties, not writing, no contact with Ava whatsoever. And you're going to have to see if your grandparents can loan you about $250, $300. And I'm going to order that when you get released, you get a job right away.
I have been looking for one.
Okay. And you have a court date, you have a judge, you have a bond, you have a no contact order. Is there anything? I've appointed an attorney for you. Is there anything else today, Mr. Regier?
Not from the state's perspective, Your Honor.
Okay. Mr. Parker, did you have a question?
Yes. Can I put a form on Ava so she can't come near me or my daughter or my grandparents' house? Because she is the one that contacts me every time and the one that harasses me.
Okay, well, you are free to look into protection orders and see if you qualify. I can't give you any legal advice or talk to an attorney about getting a restraining order. But there is a no contact order in the criminal case, but it's true that no contact order would result in you going to jail, not necessarily Ava.
Yes, ma'am. And she is the one that contacts me. I do not want nothing to do with her.
Okay. So then I would block calls. I would report it to the police. I would talk to someone about getting some kind of restraining order.
And I did that beforehand about 4 months ago, and the police officer said there's nothing they can do because that she was living in Colorado, but she posted all over Facebook that I was assaulting her and stuff when I was living here.
Okay. You need to talk to an attorney, or you need to go online and look at how you can file a protection order and see if you qualify. Okay?
Thank you, ma'am.
All right. Thank you.
Critics. State your name.
McDougal, you're fully court for threat to kill or injure and violation of injunction for domestic violence. You understand that charge? Those charges?
Yes, sir.
All right. Your attorney is present with us. What would you like to tell me, sir?
Yes, Your Honor. So I know in the last we gave the state attorney 24 hours of curative defect to show that, of course, that number that texts the victim in this case and sent the threats was connected to my client, and then that my client was in exclusive control of that phone in that moment whenever the messages were sent. So absent of that, I would
Exclusive control of that phone.
I'm sorry.
That's two different. They don't have to. There's no way to prove that he's in exclusive control of that phone. That's asking a little bit more than probable cause.
Right. From my understanding, they have the burden of proof to show that, of course, that his phone wasn't anywhere other than, what was in his possession in the time that the message was sent over to his phone. And of course, we would like to ask for a RR absent anything else to show that, of course, he sent those messages over to the victim in this case. I did some minor investigation into this to see about the victim and other cases that she did have a history of filing false reports. And I don't know if this case here can be something that can reflect similar cases in other jurisdictions where she filed false reports against other defendants.
Okay. Why is he messing with somebody like that? That's weird. I'd say as far away as I could get. Morgan, you got anything to add?
We attempted to contact the officer and were unable to.
Okay. All right. I release him on his own recognizance, but the rumor going around is that those circuit judges might not care what I do. They might revoke on their own. So, court date's going to be December 23rd at 9 o'clock. No contact directly, indirectly, or through a third party with the alleged victim. Mr. McDougall, I hope
Yes,
she doesn't
sir.
get any more.
Your Honor, I do have further questions for the court. Now, from my understanding, the victim is residing at the residence of my client. Now, as far as getting her evicted, because I know that's another issue where she is still staying at that residence, how can he approach that appropriately to make sure that he is not in violation of this no contact order?
Doesn't go back there. That's how he stays not in violation of the order. If she's there, he's not.
Right. But from my understanding, she's not a resident there, and of course, she doesn't have any ties to this jurisdiction.
Well, said that he was going through the process of having her evicted. If he's got to get through the process of having her evicted. She's a resident there.
Okay.
Step to your right to the T.
Thank you, Your Honor. That's all I have for today.
Yes, sir.
Thank you.